Parviz Jarabi, attorney at law, have been practicing for over 20 years. Our office is located by San Francisco Airport, specializing in employment law. Today's topic, recording in California workplaces. California is a two-party consent law, also known as all-party consent law. This means that except in certain situations, you cannot record a confidential conversation without the consent of all who are involved, and the consent must be obtained before the conversation begins. When a confidential conversation is recorded without that person's knowledge or permission, the person doing the recording could face legal consequences of fines of up to $2,500 and or imprisonment for up to 1 year in county jail or a state prison for making the illegal recordings. Under California law, your employers are allowed to install audio and video recording equipment in workplaces if it is for security and business purposes and applies to the business's services. However, this can only be done in common areas and areas where employees work and not in the places where employees have a reasonable expectation of privacy, such as break rooms, cafeterias, restrooms, locker rooms, or any other space where employees have reasonable expectation that they have privacy. Also, in situations where your employer are monitoring your business phone calls for quality control, phone calls taking place within California still cannot be recorded unless all participants have been informed and have consented to the recording. This can be done with a beep at the beginning of the call, which is fairly common in customer service calls. But other than that, your employer still cannot record your personal calls when you're using the business phone, unless using a business phone to make personal calls is in violation of company policy. In California, employees cannot record a private conversation with coworkers or management without their consent, unless it's done to protect one's rights or to gather evidence in certain circumstances. For example, in situations where you have reasonable belief that in order to protect your own safety or safety of others from threats of harm and violence at work, you are allowed to record conversations without consent if it is necessary in order to provide evidence. However, recordings of your employers harassing and mistreating you at work without consent is illegal when that conversation takes place in private, even if those recordings prove harassment and discrimination at work. Document your experience of harassment and mistreatment in your own words in a private place, such as a notepad or journals. Dates, times, locations, witnesses, and the details of the incident should be accounted for, and make sure these notes are kept in a safe place away from work. California privacy law can be extremely complex. For you to totally understand your rights under the law, you should contact an attorney who can help you understand the extent of your privacy protection. If you have any question on this topic, please contact my office for free consultation. Please be sure to like and subscribe and turn on your notification.